Ex parte communications pose a fairness problem in adjudication, where an agency resolves private parties' conflicting claims to a right. Allowing one party to communicate privately with the agency decision-maker would undermine fairness. Thus, the Administrative Procedure Act broadly bans ex parte communications in formal adjudication. By contrast, ex parte communications aren't necessarily unfair in rulemaking, where an agency produces rules of general applicability. Agencies often adopt rules using a notice and comment process known as informal rulemaking. The Administrative Procedure Act doesn't ban private communications between agency officials and interested parties during informal rulemaking. Sangamon Valley Television Corporation versus United States considers an unusual situation where an agency's informal rulemaking takes on an adjudicatory character. If a rulemaking adjudicates conflicting claims to a right, does fairness require banning ex parte communications? In October of 1956, the Federal Communications Commission initiated a proceeding to allocate television channels among certain communities, including St. Louis, Missouri, and Springfield, Illinois. In its notice, the agency styled the proceeding as an informal rulemaking and invited comments during a set period. Even though the proceeding was technically a rulemaking, the agency would essentially adjudicate parties' conflicting claims to the channels. Several broadcasters, including Sangamon Valley Television and Signal Hill Telecasting, filed comments with the Commission. These comments were included in the agency's formal record. Sangamon wanted Channel 2 for Springfield. Signal Hill wanted Channel 2 for St. Louis. After the comment period closed, Signal Hill's president, Harry Tenenbaum, visited the commissioners individually in their offices. Tenenbaum reiterated his desire for Channel 2 to go to St. Louis. He took commissioners out to lunch and sent them turkeys as gifts. Then, nearly 2 months after the comment period had closed, Tenenbaum wrote to the commissioners. His letter claimed that giving Channel 2 to populous St. Louis meant the channel would reach more viewers than if it went to Springfield. Tenenbaum's letter didn't become part of the agency's public record, so other parties were unaware of his advocacy. 9 days after the letter, the Commission handed down its order. As Tenenbaum had hoped, the Commission gave Channel 2 to St. Louis. Disappointed with the result, Sangamon appealed the Commission's order to the D.C. Circuit. The D.C. Circuit initially affirmed the Commission's order, but the Supreme Court vacated the decision and remanded for reconsideration after Tenenbaum's ex parte communications with the agency came to light.